You are on trial. You did not commit the crime. You know it. Your lawyer knows it. But as you sit at the defense table watching jury selection, you see something that makes your stomach drop. One by one, the prosecutor is removing every black person from the jury pool, not for any stated reason, no explanation required, just a legal tool called a peremptory challenge, the right to eliminate a juror without giving a cause. And the prosecutor is using it with surgical precision. When the final seat is filled, 12 jurors are staring back at you. Not one of them looks like you. Your lawyer objects. The judge denies the motion without comment. The trial has not even started, and it already feels over. This is what happened to James Kirkland Batson in Louisville, Kentucky in 1982. And the case that carried his name would force the Supreme Court to answer a question American courts had been avoiding for over a century. Can a prosecutor use a race-neutral legal tool to build a racially biased jury? And if they can, is that justice? Louisville, Kentucky, 1982. James Batson was a black man in his 30s, picked up by police on suspicion of second-degree burglary. Later reporting described a thin case, no fingerprints tying him to the scene, no direct physical evidence placing him inside the house, and a prosecution theory built around identification. Batson maintained he was innocent. He trusted the system, and he asked for a jury trial. During voir dire, the jury selection process, the prosecutor, a young attorney named Joe Gutman, used peremptory challenges to strike 4 jurors. They were the only 4 black people in the entire jury pool. Every single one. The defense attorney immediately objected, demanding an explanation. The trial judge denied the motion on the spot. No explanation needed. 12 white jurors were sworn in. James Batson was convicted. Peremptory challenges were not invented in 1982. They had been part of English and American law for centuries. The original idea was reasonable. Give both sides a safety valve to eliminate jurors who might be biased in ways that are hard to prove, no questions asked. The problem is what that tool became. For decades, it was the ultimate loophole. Prosecutors routinely used it to keep black citizens off juries, particularly when the defendant was black. Legal scholars called it one of the last tools of Jim Crow. The Supreme Court had tried to fix this before. In 1965, the court ruled that racially motivated jury strikes were unconstitutional, but it set the burden of proof impossibly high. A defendant had to prove the prosecution did this systematically, county-wide, case after case for years. It was a standard of evidence that no individual defendant could realistically meet. For 20 years, that ruling acted as a brick wall, until James Batson crashed into it. When Batson's appeal reached the United States Supreme Court in 1986, the question was simple: is what we see with our own eyes in one courtroom enough, or do we need years of data to prove discrimination? In a 7-2 decision, the court rewrote the rules. Justice Lewis Powell wrote that racial discrimination in jury selection is not just an injury to the defendant. It is an injury to the excluded juror, denied the chance to participate in civic life. And it is an injury to society, because a justice system that discriminates in secret can never hold the public's trust. The court created what became known as the Batson Challenge, a 3-step framework where prosecutors could finally be forced to justify their strikes. Batson's conviction was reversed, and the case was sent back. But in the background, Justice Thurgood Marshall issued a warning. Marshall agreed with the result, but he argued the new framework would not work. Prosecutors, he warned, could simply learn to give race-neutral explanations. They could strike a black juror and say, "She looked distracted. He seemed too young. She was chewing gum. He lived in the wrong neighborhood." Subjective, unverifiable, almost impossible to disprove. Marshall believed the only real solution was to eliminate peremptory challenges entirely. The court did not listen. Here is what happened to the 2 men at the center of this historic case. James Batson did not walk out of the system untouched. Rather than face a new trial, he later pleaded guilty, received a sentence, and spent years moving in and out of the prison system. His name changed American jury law, but it did not free him from the machine his case exposed. Meanwhile, Joe Gutman, the young prosecutor who struck those 4 jurors, later left prosecution work. He became a history and government teacher at Louisville Central High School, a predominantly black school. Years later, James Batson wrote a book meant to steer young people away from crime. He began visiting schools to speak. including Joe Gutman's classroom. The man whose name appears in every American law school textbook, and the man who helped put him in prison, became friends. In later interviews, both men described a shared goal: keeping young people out of the system that consumed so much of their own lives. That friendship does not erase what happened in 1982, and it does not erase what came after. 40 years later, America cannot let Batson go, because Thurgood Marshall's warning proved difficult to ignore. Studies and civil rights investigations have found that black jurors are still excluded at alarming rates. The reasons given can sound race-neutral on paper: wearing eyeglasses, being too old, being too young, chewing gum, walking a certain way, or living in a certain neighborhood. Each explanation can be framed as technically race-neutral. Each one can be accepted by a judge. The Batson rule changed the law. It did not end the practice. Which brings us to the ultimate question: if a legal tool designed to protect against bias is used to hide bias, is the problem the tool, or is it something a Supreme Court opinion can never fully reach? Every step in James Batson's original trial was treated as technically lawful at the time. The prosecutor used a recognized procedure. The judge followed existing precedent, and yet it produced the result the Constitution was supposed to prevent. Batson v. Kentucky drew a line in the sand, but without enforcement, without accountability, and without honesty, a line is nothing more than words on a page.